Yeah, good afternoon, everyone, and a warm welcome to our Amsterdam Center for International Law, the ACIL lecture with Professor Jean d'Aspremont, who presents his new work on After Meaning, the Sovereignty of Forms in International Law. The international law always arrives after meaning, Professor d'Aspremont claims, once meaning has already slipped away from the form, only leaving the form to be sovereign in international law. So it's a most interesting, intriguing argument that he will expose in his lecture today. Before I give him the screen, I want to introduce Professor d'Aspremont very briefly. He's a dear former colleague at the University of Amsterdam, but gradually left some 4 years ago, leaving a big void. So Jean, if you do get a chance, please come back and anyway visit. So it's a great pleasure for sure to have you with us virtually today. Jean d'Aspremont now is a professor of international law at Sciences Po in Paris. He also continues to hold the chair of public international law at the University of Manchester, where he also founded the Manchester Center for International Law. He's general editor of the Cambridge Studies in International and Comparative Law, a very prestigious, wonderful series of monographs, as well as the director of the Oxford International Organizations database. And he holds other advisory functions, such as the one with the advisory board of the European Journal of International Law. He was also before that a editor-in-chief of the Leiden Journal of International Law. He's one of the most prolific, insightful writers in international law, I would think. Published many books. Just now off the press, I saw is the latest monograph on the discourse on customary international law that was published with Oxford University Press. Other books include the one on international law as a belief system, as well as one that, if I understood you correctly from your text, you would like to better be forgotten, international law and formalism. I'm not sure. Let's see. It's once more great that you're with us. My name is Ingo Fenske. I'm at the University of Amsterdam. So yeah, delighted to host you. Thanks for accepting our invitation. And without further ado, the screen would be yours, Jean.
Thank you, Ingo. Thank you for this invitation, and thank you for your kind words, which were starting to embarrass me. I'm also very grateful to Alicia for setting this up. It's obviously a pity I can't be with you face to face, sharing many things. Well, I'm obviously, despite the virtual character of this meeting, I'm extremely nostalgic because, as Ingo has highlighted, I've spent close to 10 wonderful years of my life at the Amsterdam Center for International Law. So being here in this virtual room with you guys today brings back a lot of nice memories, and I'm of course very grateful for all those colleagues that are here today. I know June is usually quite hectic, so I do appreciate you came, and I also appreciate that friends from outside Amsterdam are here. So I want to thank them as well. So a quick caveat before we get going with the substance. Well, as you can anticipate, and as you could gather from the documents that have been circulated, what I'm going to talk about today is rather abstract. I'm saying it's abstract. I'm not saying it's theoretical, because that would be referring to this whole distinction between theory and practice, which I tend to resent for all kinds of reasons, and I'm not going to speak about that today. But well, it is abstract. It's not theoretical. It's abstract. I'm not going to speak about the Shell judgment, CO2 emissions, international law, and health crisis, sovereign debt, what have you. I'm going to speak about the forms of international law. But when I say forms, I mean something actually quite simple. I'm speaking today about the words, the text, the idioms, the treaty provisions, or any kind of inscription that you mobilize when you make an argument about international law. So I'm speaking about the forms. Forms is the shorthand for the words, the text, the idioms, the treaty provisions, all these inscriptions. When you speak about international law, make a claim about a wrongful act, about the ACIL, about Article 2.4 of the UN Charter, Article 4 of the Paris Agreement. If you invoke subsequent practice, if you invoke the Vienna Convention law of treaties, you are mobilizing forms. So that's what I'm speaking about. I'm speaking about all these inscriptions that we rely on when we make an argument and a claim about international law. In other terms, in structuralist terms, I'm speaking about the signifiers of international law. I'm not speaking about the signifier, I'm speaking about the signifiers. And so my argument in that sense indulge in a sort of, well, theory of science, or at least some sort of what we call semiotics. And the result is that it's abstract. So bear with me, this is going to be abstract. It's abstract, but it's simple. It's actually, what I'm going to claim is pretty plain and elementary. It's very simple. And I think, albeit abstract, it's something everybody can relate to or experience. Well, precisely because it's something you can relate to, this is something you might find outrageous and highly polemical. So abstract, simple, but possibly polemical. So how am I going to proceed in the next 20 minutes? Well, I'll just move in two steps. First, I'll say a few words about my main claim which you could infer and gather from the documents and the excerpts that have been circulated. So first, a few six remarks about my main claim. Second, a few observations on the practical implications of that abstract claim. So what's the claim? What's the claim of that book? Of that book I'm currently finalizing? Well, it's a claim that starts with a diagnosis, an abstract diagnosis. And that diagnosis is that most of the time, international lawyers, you, me, practitioners, well, they assume that the forms, that the text, the words of international law carry and deliver meaning. So there is this common assumption that the words, the text, the inscriptions, Article 38, Article 2.4, erga omnes, the Vienna Convention law of treaties, they are supposedly filled with meaning which they carry and deliver. So that's the diagnosis. It's this common assumption that shared, I think, by most of us, that the raison d'être of forms is to carry meaning. And that meaning justifies that we have the form. It's because we have a norm prohibiting the use of force that we have the inscription Article 2.4. It is because we have a certain understanding of state responsibility that we have the ACIL, the Article on State Responsibility. And so the idea that forms carry and deliver meaning, and the idea that meaning is loaded on to the form. Now, my diagnosis still goes further. It's a very simple diagnosis, I told you. It's that international lawyers think that meaning precedes the form. So the form is always secondary to meaning. Meaning is the origin of the form. So we first have an understanding of a prohibition to use force, and then we have Article 2.4. We have an understanding of state responsibility, and then we have the ACIL, which is the container of that understanding. And so there is a sort of sequence that comes with this assumption that meaning is loaded onto the form. So just again, to make sure that things stay simple, what I'm saying here is that the form is always thought as derived from meaning. So the form, the words, the text, they carry and deliver meaning from which they are derived. Meaning comes first, the form comes second. And so the form is always at the service of meaning. So we have meaning, and then we have all kinds of form, text, words that encapsulate these meanings, carry, deliver them, and are at the service of all these shared, allegedly shared meaning. This is what I call the meaning-centrism of international legal authority in practice. Meaning is always at the center of the international discourse. And the form is always secondary. And so that's what I call meaning-centrism. It's the idea that the meaning comes always first, that the form is always at the service of meaning, that the form is secondary to meaning. I think most international lawyers, whether scholars, practitioners, what have you, they think in meaning-centric terms. I would like to push this diagnosis further, and this meaning centrism of my claim that there is a dominant meaning centrism in international legal thought and practice. I think it's an attitude, or it's an understanding, it's a posture which permeates the international legal discourse across the board. It's obviously very tangible in litigation and judicial practice. The meaning must be extracted from the form by the judge. Because because the forms that are applied or that are deemed applicable, they carry and deliver meaning. And the role of the judge is obviously to extract that meaning. But I think you will find centrism in most of the scholarship. Of course, you find this in the scholarship that is geared towards the clarification of forms, which I think is 70% of the scholarship. But even reformist or more critical scholarship that seeks to change or alter or contest the meaning found in the forms and in the text of international law, again, abides by a presumption that forms carry and deliver meaning. And I'm going as far as claiming that what we call critical legal scholarship, or all those critical engagements with international law, they are equally meaning-centric. If, for instance, you make the claim that meaning is created at the moment the form is interpreted, you continue to locate meaning in the form. If you claim that there are hidden meanings in the treaty, or hidden meanings in a discourse, hidden meanings in a concept, or hidden hegemonies or hidden hierarchies, which is something the critical legal scholarship is usually quite keen on scrutinizing, you continue to presuppose that the legal forms, that forms of the discourse, carry and deliver meaning. And if you do as well some what we call oppositional reading, which is the very classical tool in critical legal scholarship, that's when you reverse the hierarchies of concepts and text. It's what we call oppositional reading. Well, again, you presuppose a meaningful hierarchy before you flip it. So again, it's meaning-centric. All the oppositional readings that we witness in critical legal scholarship are meaning-centric. The same goes with scholarship that scrutinizes the world-making dimension of international law, the performativity of international law, the extent to which international law makes the world and makes all the injustices of the world. Again, the same presupposition. You presuppose a meaning carried by the form, and you presuppose that the form project that meaning on the world to shape it. Again, all this is quite meaning-centric. And last example is all these claims about the indeterminacy of the content of legal text. If you make a claim about the interdeterminacy of legal text, you presuppose that the text carry and deliver meaning. You just make a claim that that meaning is not determinate. So even these claims about the indeterminacy of the language are meaning-centric claims. So hence, I go as far as saying that, that meaning-centrism dominates in the whole spectrum of international legal thought and practice. So that's my diagnosis. Well, and here comes now my claim. Well, I would like to challenge that meaning-centrism. And that comes here, the possible heretic part of what I'm telling you today. I do not believe that forms carry and deliver meaning. I do not believe that meaning precedes forms. I do not believe that there is any meaning to be found in the forms of the international legal discourse. I don't think there is meaning in the text, in the words, in the idioms, in the treaty provisions, in all the inscriptions that we mobilize to make our claim. And my claim is that meaning is always absent. It's always absent because it is deferred by the form, deferred in the sense of deferral. meaning is always pushed back by the form. Actually, the role of forms, the role of text, the role of words is to push back meaning to other forms. And so the way I look at the international discourse is just a set of forms pointing away to other forms, constantly pushing meaning away. So a form points away to another form, and then meaning vanishes from that form and goes on to the next form, which in turn points away to another form, and so on and so on and so on indefinitely. And so self-defense refers to the use of force, which refers to the travaux preparatoires of the Charter, which refers to Article 31 of the Vienna Convention of Law Treaties, which refers to another text, which is the travaux preparatoires of the Vienna Convention, which refers to forms of hermeneutics, which refers possibly to forms of social justice, and so on and so on and so on. The deferral of meaning is never complete. It's always ongoing. Take another example, a wrongful act. It refers to the forms of attribution, which refers to some specific provision of the article on state responsibility, which refers to the ACIL commentary, which refers to the work of some tribunals, which refer to some forms of hermeneutics again, or the Vienna Convention, and so on and so on and so on and so on, indefinitely. And I could multiply the example. And so meaning, and that's my claim, is perpetually deferred. And because it's always deferred, it's constantly absent from the text, from the words, from the forms of the international legal discourse. And so that's why I think the very question, what's the meaning of that text? What's the meaning of that word actually makes no sense, because forms do not carry and deliver meaning. Forms refers to forms. Forms point away to other forms, thereby constantly pushing back meaning. And because meaning is constantly pushed back, it's never there. It never stays in the form. It's always absent. And that bears important consequences, in my view, which is that if meaning is always absent, they are just forms pointing away to other forms. So what we do as international lawyers actually is not to deal with any extraction of meaning from forms. We're just dealing with forms deferring meaning to other forms pointing away to other forms. There are forms and just forms. There's no meaning in the story. Or in structuralist term, you would say they are only signifiers. There are no signified. So if I were to wrap my claim in more theoretical or disciplinary terms, I would say that I'm claiming, I'm advocating a move away from Saussure, traditional structuralism. This possibly explains why I'm speaking about the sovereignty of forms, and that's the title or the subtitle I'm giving to that book, and Professor Vensky has alluded to that, because there are forms and only forms referring to forms, always pushing away meaning. Well, the forms, they preside over the legal discourse. They are nothing else than forms. There's no meaning. Meaning is absent. They're only forms. The forms are sovereign. It's just a matter of forms. And this domination of forms in the discourse is exclusive and unqualified. So here you have my claim. Your forms, only forms, pointing away to forms. So words, text, pointing away to other texts and other words and other idioms and so on independently, and meaning is never there. Meaning is never to be found in the international legal discourse. That's my claim. And I call this the sovereignty of forms. The use of sovereignty, I may wish to say a word about this. I don't hide it. There is a bit of sarcasm behind the use of that word, which I use in the title. I mean, it's a bit of a provocation, because I think the term sovereignty is the most sloppy notion of the entire international discourse. I mean, it means everything and nothing. It's a shorthand used by everyone, but as a sort of definition avoidance technique, it's really a term of convenience in which most people put absolutely no effort. And that's also why I've never used that term in my entire career, I don't think you'll find the word sovereignty in any of my writing. I find this just too sloppy, too sloppy. But the thing is, the reason nowadays I've broken the ice and I've used it is simply because I think it's a wonderful example of this deferral of meaning. You have a form, sovereignty, it's an inscription, that refers to as many things as there are international lawyers. So that refers to other forms, which refer to other forms. It refers to the state. It refers to a certain type of order. It refers to a certain organization of competences, what have you. Sovereignty is the embodiment of this deferral of meaning I'm speaking about. So that's one reason why I have put it in the title with a bit of sarcasm. There's also another reason. Sovereignty, in the way I use it, I think, is a type of sovereignty, because the sovereignty of international lawyers, the sovereignty that you find in almost every second sentences of international legal scholarship, is a non-sovereign sovereignty. And the sovereignty of international lawyers is always dependent on, I don't know, statehood conditions, an effective government. Its working depends, according to the different theories, to recognition. It's qualified by self-determination. It might be qualified by other things. It is a non-sovereign sovereignty because it can be qualified, it can be conditioned. The sovereignty of forms I'm speaking about is a sovereign sovereignty. It is unconditional. Forms refer to forms without the users of the discourse, without you and me having to recognize that forms refers to forms. Forms refer to forms, and that's the end of the story. They are properly sovereign, not like all these sovereign entities we spend our time writing about. At this stage, I'd like to make an important observation with a view to nuance a little bit what I've been saying so far. And I'm still actually trying to unpack my claim. Very soon I'll tell you a little bit what the practical consequences are, but at this stage I would still like to unpack my claim a bit further. So I'm saying that meaning is constantly absent from the forms of international law, from the text, from the idioms, from all the forms and inscriptions. That doesn't mean, however, that the forms of the international discourse are empty. Because if these forms were completely empty, at the end of the day, they would just be inscriptions. And the difference between all these forms will just be graphic or graphical. Well, I'm not actually saying that the differences between texts of international law, between idioms, between forms, is just graphical. No, and here is another part of my claim. I think these forms, to fall, wrongful act, the Vienna Convention Law of Treaties, what Article 31, what have you, these texts, these forms, these idioms, they bear the trace of other forms. So they have an identity, and a distinct identity, but the distinct identity takes the form of a trace of the other forms. Actually, they bear the trace of the forms to which they point. So 2-4 bears the form of 51, which may bear the form of the Caroline, which bears the trace of the Caroline. So they have the trace of one another. And it is through these traces that they point to one another. And so they are inhabited. They are inhabited by the traces, some people say the ghost, of other forms. And if we say traces or ghost, it's to indicate that these traces of other form is not meaning. And so I'm not replacing meaning by another kind of second order meaning. No, this is the traces of other forms in the forms. It's these other forms that are just passing, vanishing. So in 2-4, you have a trace of 51, but the moment you look at 51, you're already in the form 51. So the trace is gone because you've gone to Article 51. And excuse me if all my examples are just worded in international lawyers' jargon, but I guess this is something you can relate to. And so you have in forms, in the text, in the words, in the idioms of the international legal discourse, you have the traces of other texts, other forms. Wrongful act has a trace of attribution, which has a trace of some provision of the RCY, which has the trace of the commentary of the LC, which has the trace of some ICJ case law, and so on and so on. And I think all the forms of the international legal discourse, all the texts, the forms, the idioms, they are inhabited by these traces of the other forms, which are the forms to which they point away to. So the consequence is that meaning can only be passing. It's never stopping. Now you have a trace, but the moment you see that trace, you're already in the other form. The trace of self-defense in 2-4, well, it brings you in self-defense. Then you see the trace of something else and you're already gone. And so that leads me to say that, so texts, words, all the forms of international law, they don't carry or deliver meaning. They are just sites of passage. Meaning just passes but never stops, and you can never capture it. So that's why I'm saying there's no meaning, but they're not empty. The forms are not empty. They are sites of passage. They have an identity that is constituted by the traces or the ghost, as some others would say, of other forms. I'd like to make another brief observation, hoping that I'm not going to lose you. Well, I'm saying that these forms, these texts, these words, they're inhabited by the traces of other forms, other texts, and so on. These traces, they're not fixed. So in 2-4, you find a trace of, I don't know, self-defense. In Article 2 of the Article on State Responsibility, you find a trace of breach, and then breach carries the trace of something else. Well, this is my reading of these forms. And so there is no fixed traces. There are no fixed deferral for each and every form of the international legal discourse. Every user of the discourse will actually activate different traces in the form. If you and me look at I don't know, well, 2-4, I've overused that example. Article 31 of the Vienna Convention on the Law of Treaties on Interpretation. Well, we will experience different traces, and the meaning will be deferred to different forms. And maybe the next minute you will look at that text, at that inscription, and the meaning will be deferred in a completely different way than 1 minute earlier. And so all this to say, I'm not replacing one meaning-centrism by another. You have these forms that are sites of passage. Meaning is always in flux, never stopping. And this flux is never the same at any moment and for any user of the discourse. So that's my claim. And I hope that I've managed to unpack some bits of this, I think, pretty plain and simple claim. And I hope also you understand that my claim is very different from the claim of saying, well, the forms of the international discourse are just indeterminate. I hope that has been clear enough that my claim is not about indeterminacy, because simply there's no content to which you can deem determinate or indeterminate. Forms do not carry and deliver meaning. Okay, so that's my claim. What are the implications of this? Why was it worth waiting until now? Was it worth just trying to survive through my very abstract pointers? Well, I think if you agree with me that maybe our meaning-centric attitude can be questioned, well, there might be a series of consequences. Or in my small book, my books are always small and thin. In my new very thin book, I've identified 7 implications. Today, don't worry, I'll just pick maybe 3 or 4, also taking into account the time limitation. But the greatest and most obvious implication is about the way we think about interpretation. Interpretation, as it is usually taught, as it is usually experienced, as it is usually practiced, is about extracting meaning from the forms of the international legal discourse. That's how we approach interpretation. You know? In a way, we're very dependent on a sort of hermeneutic tradition of interpretation. But well, I'm coming and I'm saying, well, there's no meaning to be extracted because the forms do not carry nor deliver meaning, which means that interpretation cannot be about determining the meaning of forms, since meaning is absent. So I do appreciate that one consequence is that is a charge against our hermeneutic tradition, and obviously I'm more promoting a sort of poetic approach to interpretation, and this idea that the interpreter does not extract meaning, a meaning that is there. No, the interpreter solicits a meaning he or she hopes for, but that will never come. And so interpreting is about soliciting the form for meaning that is hoped, but that will never come. So I appreciate it's quite tragic. I'll probably lose the last friends I've in this world, but it's tragic. It's tragic because when you think of it, how many failed arguments, failed articles, failed judgments, failed interviews, failed careers, and maybe failed lives and loves for interpretations that have been deemed invalid, whereas meaning was always absent from the words and the text being interpreted. So there is a bit of a tragedy. Well, the point is not that this is tragic. The point is that I think we should just revamp the way we think and approach interpretation. Interpretation is about appreciating not the finite possibilities or the definite possibilities. It's about appreciating the infinite possibilities of text. And so I think interpretation should always be about over-interpretation. It's about trying to appreciate the infinity of signification of the text. The text is an infinite space of signification. And so I think, yeah, so that's one implication. So I'm not going to elaborate on this further. Maybe in the course of the Q&A, I can possibly flesh this out. But I do think that our common understanding of interpretation are probably not spared by my anti-meaning-centric claim. Or maybe an important caveat: I am not saying that everything goes. This is not a nihilistic claim. Remember, the meaning is deferred by the forms to other forms, but depending on the traces that have been found by the user in the form. And so the deferral of meaning and the fact that a form points to another form, to another point, to another form, to another text, to another provision, it's never anarchical or accidental. It is dependent of the traces that are found in the form. So my claim on interpretation is not a nihilistic one. So first possible implication, I called it concrete. That's concrete by my standard. We have to revamp our understanding of interpretation. I think our second implication, I tend to think that we also have to reinvent the way we approach agency, the way we look at actors, the way we actually speak about all these international lawyers carrying out the interpretation of international law text. Because it seems almost a natural consequences from my claim, which is that, well, my claim remains a quite structuralist one. The focus is on structure. So if we only look at the structure, the agent is out. Certainly. And remember, I also said that because forms point to forms, to earlier or later forms, the author himself or herself is a form. Quote in this course. When you say the treaty parties, it's just another form. The treaty parties will then refer to some text of the travaux préparatoire. So the author is just a form already captured in the form. But that's the old death of the author argument. So yes, there is. I think my claim comes with a bit of that, which is the author is just a form already quoted and captured in the form, and the author has no meaning. And because the author has no meaning as a form, it can have no will or anything you can rely on. I mean, it's Roland Barthes' death of the author claim. It's true. I think my claim brings about the death of the author as an independent category. But that doesn't mean that we shouldn't be studying the international lawyers or all the actors of the international discourse. I think it's rather that we should be studying them differently. And here you may appreciate a little bit more the Butler of Foucault influence, which is that the structure must always be activated. The structure must be activated. And to work, so the forms to start deferring meaning, 2.4 to start deferring meaning to self-defense, or Article 2 of the ACIL to defer meaning to the commentary, well, must be activated by the user, by the interpreter. So the interpreter or the international lawyer is always the one putting in motion this deferral of meaning from one form to the other. So I think it's worth continuing paying heed to the international lawyer, but not as an author. Clearly, I don't believe anymore in this idea of an author or the idea of origin. I think the international lawyers matter as the activator, as the users of the form, as the one that puts the deferral of meaning between forms into motion. So yeah, if you refer to the ICJ, well, it's another point actually I need to highlight before I mention one final point. So when I say that the agent or the actor, the lawyer can be looked at in scholarly studies and should be looked at because these are the actors putting into motion all what I've been saying, this deferral meaning. Well, we should also always remember that as soon as we look at them, they just become forms. When we speak about the international lawyers, when we speak of the International Court of Justice, there are forms absorbed. The ICJ will refer to some sort of authority. It will refer to some sort of 13 male, 2 females deciding on the fate of the world. But it's a form, which in turn will refer to other forms. So when we pay attention to these actors, we pay attention to forms. So James Crawford, to give another example and to whom I pay tribute here, is himself just another form of the discourse. It's a form, like all these authors we refer to are just forms. The author is just a form as all the other forms. So that's the consequences for agency and the study of the actors. A third implication, and I see that I've not been yet reminded that the time is limited, but I'm really reaching the very end. I want to say a few words about the implications for critique, and then maybe I'll have some final considerations. Well, there are implications for critique, or what we call the critical attitude. Well, the first implication is that forms do all what they do without meaning. They are sovereign, and that's no call for complacency. Precisely because forms do all what they do, they destroy the world, the Amazon forest, and what have you. Well, we need to scrutinize what forms do, because it's forms doing this through their pointing away to other forms. So my point is that we need to remain very critical towards the work of forms, because we only have forms that defer meaning perpetually. We need certainly this greater critical attitude towards form, but again, critique shouldn't be about unearthing hidden hierarchies, hidden meaning, privileged meanings, privileged positions, privileged centers, because the forms have no meaning. The forms do what they do, they distribute roles, but without carrying meaning. And so I think the way we want to conduct critique is by forgetting meaning and putting the emphasis on forms. Also, I think it's important to bear in mind that when we scrutinize the forms and all the mess they make in the world, we appreciate that we cannot be outside the form. We criticize the RCWA, we cannot be outside the RCWA. We criticize the Treaty of Paris, we cannot be outside the Treaty of Paris. So there is no meta-critical standpoint, never, because your critique is itself absorbed by the object of your critique. Your critique of the form is absorbed by the form. You're always within the form. So what is the critical attitude then? I mean, I appreciate at this stage, I had warned you it would be abstract, but maybe you didn't anticipate it would be that abstract. But don't worry, I'm getting there. What should be critique about if it cannot be about meaning and if it's bound to be within the form? Well, critique is bound to be a type of formalism. I know that's quite polemical to say that, but I think critique, being critical, is about taking a very formalistic position, which is to be critical is a commitment to forms. But I think it's a commitment that should be pushed so far that it is turned into treason. It is an overcommitment. So in a way, I would say that critique is a formalism that boils down to an over loyalty to the form. You should be so loyal to the form that you turn the form upside down or into absurdity. It's about plunging into the form. It's not about trying to be outside the form, outside the UN Charter and have this meta standpoint to reevaluate the Charter. No, it's about going into the text of the Charter, in the text of the Article on State Responsibility, into the WTO treaties. It's about being and accepting being in the form. It's about, I mean, I want to say it's about being in love with the form and appreciate the semantic plenitude of it's about being textualist. And that's yet another polemical claim of mine. Yes, I think critical means being textualist. So I think all this critique must be, in a way, must be rethought. There also, and I'm not going to go in there. I think you have enough on your plate at this stage, enough to digest. There are of course huge consequences for other things we do, which is historicization, translation, comparison. Obviously, if you're only forms pointing away to other forms, there is no contextualization possible. You cannot immerse yourself in the context and be outside the form, because the context is already in the form and the form in the context. So the form and the context cannot be distinguished. So when you do historicization, translation, comparison, you cannot just claim to have this contextualist posture, because you are still in the form. You cannot be outside the form. And also you can't claim that you are historicizing, translating, comparing pre-existing meaning, because the forms, again, do not carry and deliver meaning. So when you compare them, actually what you do is just you pour forms onto forms. You're not comparing the meanings of different forms. What you do is just you maximize, you create new forms. There's a wonderful text of Benjamin on translation on this. Actually, when you translate, you do not actually put into forms a pre-existing meaning. No, you just create forms and other forms, and you throw forms on forms, and you do not contribute to any clarification of meaning. And the same goes for historicization. I mean, I'm not going there. I think I've said enough. I think I'm well beyond my time, and I do appreciate that Professor Venske is way too kind with me. I'm a privileged guest. I appreciate. So I will leave it here. Well, I hope you've survived my little abstract story and this little post-structuralist journey. I believe you knew before coming that I was not going to be nice and complacent. So thank you for coming, and very much looking forward to the Q&A.